Good day and welcome to today's webinar. We will get started in just a moment. Welcome everyone. This webinar is being hosted by SAMHSA's Gaines Center. Today, a panel of experts will be sharing information as part of an ongoing virtual learning community. This being the second session on data sharing agreements and confidentiality concerns across criminal justice and behavioral health partners. I'm Richard Van Dorn. I'm a Senior Research Associate in the Gaines Center, and I will be serving as the moderator for this event. Before we get started, I'd like to share the following disclaimer. The views, opinions, and content expressed in this presentation and discussion do not necessarily reflect the views, opinions, or policies of the Center for Mental Health Services, the Center for Substance Abuse Treatment, the Substance Abuse and Mental Health Services Administration, or the U.S. Department of Health and Human Services. This virtual learning community on information and data sharing has been structured as a 1-hour presentation webinar with a 1-hour open discussion group which follows immediately. A number of you have submitted questions for discussion when you registered, and we will address those during the discussion group portion of this event. Additional questions can be posed by typing your questions into the Q&A pod on the right side of your screen. A few more reminders. First, this webinar is being recorded. Slides will be available in a few days. A downloadable certificate of attendance will be available at the end of the webinar. This slide provides the agenda for today's event. Dr. Victoria Chow from SAMHSA's Office of Behavioral Health, Equity and Justice Involved is with us today to welcome registrants and provide additional information about the Information and Data Sharing Virtual Learning Community Series. After her welcome, I will introduce our webinar presenters and discussion group expert participants. Victoria, I'll now hand the microphone over to you.
Also known as SAMHSA. Welcome to the Data and Information Sharing Virtual Learning Community, hosted by SAMHSA's Gaines Center. The Gaines Center is SAMHSA's National Technical Assistance Center focused on expanding access to services for people with mental and/or substance use disorders who come into contact with the justice system. Today, people living with mental and substance use disorders are at their most vulnerable state. This includes people who are involved in the criminal and juvenile justice system. Behavioral health crises and concerns are mounting in today's current environment, where COVID-19, unemployment and closing of businesses and behavioral health services, racism and excessive force against communities of color, and subsequent civil unrest are converging into a confluence of stress. In the U.S., prisons and jails are overrepresented with individuals who have mental and substance use disorders. In alignment with SAMHSA's mission to reduce the impact of substance abuse and mental illness on America's communities, SAMHSA recognizes the need for mental and substance use disorder treatment for individuals in contact with the justice system. SAMHSA continues to promote collaboration and partnerships across disciplines and sectors to better serve individuals with mental and/or substance use disorders and who are at risk for or who are already incarcerated. In this intersection of criminal justice and behavioral health, SAMHSA continues to promote the identification of individuals with mental and/or substance use disorders, use of evidence-based screening and assessment during pre- and post-adjudication, diversion of individuals from the justice system into home and community-based treatment, provision of training and technical assistance for law enforcement officers, juvenile and family court judges, probation officers, and other judicial decision makers, and the assurance of equitable opportunities for diversion and linkage to community services and supports for all populations in order to decrease disproportionate minority contact with the justice system. Today's webinar, titled Data sharing among criminal justice and behavioral health partners, addressing data sharing agreements and confidentiality concerns, is the second of 3 webinars for this virtual learning community. Today's webinar will be followed by a third and final webinar in this series on July 28th, focused on mechanisms and platforms for efficient data and information sharing. During these challenging times and this current environment, SAMHSA would like to thank the Gaines Center, the speakers, and the participants on this webinar for your participation in this virtual learning community and your continued dedication to improving the behavioral health of individuals incarcerated in the criminal justice system. Richard, back to you.
Terrific. Thank you, Dr. Chow. Following up on Victoria's remarks, the virtual learning community and its May, June, and July topics were born out of the recognition that many jurisdictions are seeking assistance with their efforts to use data to improve outcomes for people with mental health and substance use concerns, and with good reason. As cross-system information and data sharing allow for individual-level information to better understand and inform immediate and long-term community needs, improve services, interventions, systems, and policies. However, there are challenges, including legal and information security issues that will be discussed today as they relate to data sharing agreements and confidentiality concerns. And a quick plug for the July VLC webinar. It is going to be on July 28th, and that one will be addressing mechanisms and platforms for efficient data and information sharing. So today we have 3 panelists who will be sharing information and experiences about programs, lessons learned from implementing information and data sharing initiatives in their local jurisdictions. Keith Brennan is Assistant Counsel at the New York State Office of Mental Health, representing the agency in matters of regulatory enforcement, development and implementation of new regulations, and institutional reform litigation. In his time with OMH, Mr. Brennan has been involved in legislation related to outpatient commitments and gun control. Finally, Mr. Brennan provides technical assistance to behavioral health providers, local government officials, patient advocates, and law enforcement. Next, we will have Andrew Brown speaking. Andrew is Program Coordinator of the Ottawa County Recovery Court in Michigan, which is currently one of the National Association of Drug Court Professionals' 8 national mentor courts in the U.S. Mr. Brown holds master's degrees in public administration and social work and is a graduate of the National Center for State Courts Fellows Program. Our third presenter is Dana Fondell. Ms. Fondell is Senior Clinical Manager of the Clinical Redesign Initiatives team at Camden Coalition of Healthcare Providers in New Jersey. Ms. Fondell works with clinical providers to design, pilot, and activate workflows to serve complex patients, including the expansion of medication-assisted treatments and the activation of health information exchange data for clinical care. Ms. Fondell began her healthcare career researching harm reduction models, then became a registered nurse, and eventually transitioned into health systems work as a program manager and strategic planning consultant. After the webinar portion of today's event, Keith, Andrew, and Dana will be joined by Aaron Truchell as discussants during the discussion group component of the session. Mr. Truchell is Director of Analytics and Informatics at Camden Coalition, where he supports the organization's data and research activities. Specifically, he supports the integration of individual-level data across health, criminal justice, and other sectors. And he worked previously as a program manager at CamConnect, a nonprofit data warehouse in Camden, New Jersey that analyzes and reports on data on the city of Camden's revitalization. So very exciting for today's webinar, followed by the 1-hour discussion. So I would like to now hand things off to Keith Brennan. Keith, take it away.
Thank you, Richard. Hello, everyone. So I'm going to start off talking about, I guess, what you would call some of the technical features of information sharing. I guess I get to do that because I'm the lawyer. And, I think sometimes, I've had many conversations with some of my clients at the agency and folks from providers over the years, and I have often observed a lot of trepidation about, how we overcome what we see as obstacles to information sharing, because it seems to be an huge body of arbitrary rules that don't seem to make a lot of sense. But what I would urge you to look at it much differently than that, as a problem-solving exercise. I'm going to start off with a metaphor. And it's like if we see an apple, we all know what apples are. And if we try to swallow an apple whole, we will choke. So what we do is we just eat the apple one bite at a time. And I think if you think about what I'm going to share with you over the next 10 or 15 minutes in terms of just taking, one bite of the apple at a time, we kind of have a framework for problem solving. And the way I do it is to treat these things as a transaction, because that's really what they are. Someone has information and someone else wants or needs the information. So that's the way I'm going to explain how we can work through some of this stuff. And then, you just plug in the pieces, parts of your particular situation, and hopefully that'll lead you to some helpful solutions. Slide, please. So we're going to start off really with the basics. So break it down. What is it? Who has it? And who wants it? And the what is it is very important, because that's going to help us decide which rules apply. And it's going to also kind of make us focus on doing what we need to do and no more and no less. And by that, I mean, basic things like that we all know. We're going to share information that's necessary, and only that which is necessary. And who has it, that's important, because some people are subject to certain rules, other people aren't, and we want to know that going forward. And who wants it, the same thing is true. And this is, when we look at this, we're going to even break it down a little more, because the who has it and who wants it, we're not really going to look at what we call each other, but what our roles are. Because, for example, law enforcement may have a certain role. They may be, for example, monitoring treatment that's part of some kind of community supervision plan. Or law enforcement may be involved in an ongoing investigation of a criminal matter. So, how we want to move forward is going to really depend on who wants and who has in terms of the roles that folks have. Okay, slide, please. Okay, so the what is it? So usually we're talking about a clinical record, and the clinical record is covered by HIPAA. And this is important for us to remember also, that it's also going to be something we're going to have to exchange information in a way that comports with state requirements. And I know in New York State, for example, there are provisions of the mental hygiene law that govern exchange of information. They are often superseded by HIPAA. And the rule about that is whichever is the strictest, and by strictest, what I mean is whatever is the rule that provides the greatest amount of protection to the information, that is going to govern. But it's something you need to be aware of, because in your state, you want to make sure that not only are we complying with CMS regulations and HIPAA, that we're not running afoul of state requirements. Drug and alcohol treatment records, we know that they are treated differently than, HIPAA records. Although we also all know that a lot of times, both of these types of records might be in a clinical record. So we want to make sure that we're being very careful about the exchange of information, and we know exactly what we're asking for, what we're sharing, and what we're receiving. HIV records. This is another category of information which is subject to additional protections. So if the records that you're sharing include information that would identify someone's HIV status, you need to make sure that you're complying with, the prohibitions and the protections that pertain to those records. And the important thing here is, once again, a clinical record for a particular person may have a mishmash of records that are governed by these different laws or all of them. And lastly, I added this just so that to be a completist, but criminal record information is covered by the U.S. Department of Justice Information Services Security Policy, and this probably is going to impact your activities less in terms of what we're talking about today, but you should know it's out there because there may be instances where the information, the clinical record, the file, whatever it is, could potentially include records that are governed by this additional set of rules. Slide, please. Okay, the security rule. And this is the main thing that we're talking about with respect to HIPAA. It ensures confidentiality, integrity, and availability of protected health information created, received, maintained, or transmitted. So that's very encompassing, and we should look at it that way. Confidentiality applies to the clinical record, of course, but more broadly, it applies to any information which would tend to identify the person as a recipient of services. And that's kind of a broad general definition, but it also pertains to all of these records. So if it's a Part 2 record or it's a HIPAA record, the test is going to be whether if we shared it, it would identify an individual as a recipient of these types of services to a third person. The security rule protects against reasonably anticipated threats to security and ensures compliance by the workforce. And then for business associates, the health tech information technology for economic and clinical health, that's a mouthful, high tech, really pertains to the processes and mechanisms by which we share information. And we all know that we've had to, over the past 10 years, look very closely as technology has evolved to the ways that we share information. And, you know, for a long time, it was a challenge for entities to share information because data need to be encrypted, for example. High tech would also pertain to, you know, can we share information on a telephone? Do we need to use a facsimile? And I would point out that any of you that are currently involved in this kind of work, you've probably been spending a lot of time with high tech related issues because during the COVID-19 crisis, CMS, and also where I live, New York State, has created emergency executive orders and regulatory changes and waivers to allow for easier exchange of information because people can't be face-to-face. Patients can't go into a doctor's office and so on. So we've seen a temporary expansion, for example, from the requirement that information must be exchanged digitally through in an encrypted way to a more broadening allowance that permits Zoom and Skype and FaceTime, and even recently, and this is probably short-lived, but the exchange of clinical information over the telephone. And so these are temporary things, but I point them out because they really help to illustrate what high tech is about. It's not the, going back to my earlier slides, it's not the who or what, it's really the how. So these are all things that we want to keep in mind when we're dealing with requests for information, whether we're the one making the request or we're the one receiving the request. Slide, please. Okay, protected health information. Okay, to protect an individual's right to privacy includes anything which would tend to identify the individual as a recipient of care. And I kind of just explained that a little bit, but really it's more than just a document. It could be, and I use this example, and it's a little bit of an exaggeration, but it's also technically correct, and I find it illustrative, where if you are somewhere in public, you are in a restaurant, you are at your child's soccer game, you're at the grocery store, and you're with your friends, and you see someone, and your friends know that you work at a mental health clinic, for example, and you say hi to the person in the vegetable aisle, and your friend says, "Who's that?" And you say, "That's a person that's a client of mine from work." You just really share protected health information about that individual in a way that's prohibited. And like I said, that's a bit of an exaggeration, but I think it's good to keep in mind that really what we're not talking about is just the documents. We're talking about information. So we should always keep in mind when we're sharing information that these rules apply and that they go beyond just what is included in the paper file or the digital file, which we would often refer to as the clinical record. Now, the covered entity is a person or entity subject to the privacy rule. Who's subject to the privacy rule? Well, basically, the person subject to the privacy rule would be anyone who, is involved in the Medicaid or the Medicare system, because the privacy rule is a CMS promulgated enforced rule. And in addition, I know in my state and most states, incorporated by reference into the licensing schemes is the privacy rule. And like I'd mentioned before, New York happens to have a statute that also creates privacy. So the covered entity is probably anyone in healthcare or anyone who deals with folks in healthcare and with, as part of their job, be exchanging information. Okay, the privacy rule is designed to be flexible and comprehensive to cover the variety of uses and disclosures that need to be addressed. Now, this is very important, and this is it's important because the rule is designed to protect the individual's right to privacy, but also to let us all do what we need to do to provide care to the individual, to manage the care for the individual, often to bill and provide revenues based on the provision of care to individuals. So sometimes we think of the rules as overly onerous, but I think it's helpful to keep in the back of our minds the fact that the rule is designed to allow us to do what we need to do. We just need to do it in a certain way that protects the interests, the privacy interests of patients. And next slide, please. Okay, HIPAA. Okay, information can be shared for treatment purposes. That's an exception to HIPAA. And I use that as an example of what I'm talking about in terms of the flexibility. So we see HIPAA as a barrier, but HIPAA is also an opportunity. So HIPAA says if you're doing these things, you're permitted to share information. So you can share information for treatment purposes. In many instances, a referral of care falls within the definition of treatment. And that's important to remember. And then I would add to that, like I mentioned at the very beginning, so for treatment purposes, if you're a treating physician or clinician or a clinic or a provider, you may need the entire clinical record. And I think HIPAA allows for the sharing of information for you to do what you need to do. If it's a referral, if you think about it, probably on a referral basis, the entire record doesn't need to be shared. So what needs to be shared? Often it's referred to as a referral package. So it's the basic information that would help a provider analyze whether their level of care or their care environment would be appropriate for the patient. So every instance of appropriate sharing and every instance of an exemption under HIPAA doesn't necessarily permit the same amount of sharing. So the sharing really needs to be tailored to the purpose. Okay, a general consent with an opportunity object. This is really the silver bullet for managing, information sharing. It's not always possible, but general consent and, often the most efficient way to do this is to think hard about your in-processing document. So when someone comes in and they're accepted as a patient to a clinic or to an outpatient program or to a residential program, there's going to be a lot of paperwork and a lot of information that's shared with the patient at the time. And the consents really should be part of that effort and that activity. A general consent for HIPAA, can be shared with providers and so on and so forth. It can be limited. But I know that HIPAA prevents, for example, the sharing of information with an adult person's family, absent, unless they are the guardian or some surrogate decision maker. So general consent probably wouldn't include that, but it may include consents for the sharing of information with a managed health care plan, for example, and often it'll include consents for the sharing of information between providers in a system, a hospital system, and we see this more and more with electronic records, that the consent at the beginning when the person is in process it'll be basic language. There's an opportunity object, but it allows the system, the hospital system or the system of care to create electronic medical record that's accessible by all providers, so that if you're at your if you're at your clinic and then you need to go to a specialist, they all have access to all the information about you, because the idea is, and I think we would all agree this is true, that really leads to better outcomes when providers have more information about patients. Now, 42 CFR Part 2 is really a different ballgame altogether. The sharing of alcohol and substance abuse treatment records are a lot more strictly protected, and disclosures without patient consent are a lot more problematic. There aren't the same exceptions for Part 2 that there are for HIPAA. So really, the idea that we're going to try to achieve consent from the patient is much more important with respect to the sharing of Part 2 records, because it's really the best, and in a lot of cases, unfortunately, it's the only way of sharing information. Now, both HIPAA and Part 2 have provisions that allow sharing after a court proceeding. If there's a court order, then information can be shared. There's rules that pertain to how a court order is obtained. And there's also exceptions in both of them for information sharing that is required by law. So there may be statutes in your jurisdiction, or depending on your activity, there may be federal statutes which themselves permit the sharing or may require the sharing of information. And so, those are things that we want to look at when we're thinking about the challenge of information sharing. A court order disclosure, what could this mean? This could mean a subpoena, or some kind of individual, a person or entity files a request with the court. It could be a subpoena, it could be a show cause order. It would really depend on your jurisdiction. Or a court order disclosure could be more broad. There could be a class action suit, for example. I was involved with some of my colleagues at PRA in the implementation of a class action suit in the state of Washington. And part of that, really required the sharing of information for the remedy, the court-ordered solution to the case, for the remedy to be achieved. So in that case, you have a court order that it's not really one person asking the judge to tell another person to share information. It really creates the authority for all the people that were members of that class. And with respect to those individuals, certain information could be shared, and in fact, had to be shared. Next slide, please. Okay, so consents are time limited, and that's an important feature of consents. And in terms of if a consent has expired, well, then it's worthless at that point. And if a consent does not have a time limitation, then it's not valid from the get-go at the same time. So I think that it's important when we put together, for example, in processing documents like I talked about before, that we create, a rational way to create, time limitations, that they're clear in the documents, and then we have a way of tracking them, or at least, figuring out when we need to, execute new documents. Sometimes time limitations are derived from a different source. For example, if someone's in community supervision, they're on parole or probation, and part of their parole and probation requires them to attend certain treatment, for example. Well, and then they consent as part of their parole or probation, they consent to the sharing of information for that purpose. Well, in that case, the consent is really time limited to the term of whatever, the probation or parole would be. They're subject to revocation by a patient. This is true. It may be less true in those unique examples that I just mentioned. For example, if you are on parole and you have to attend certain types of treatment, and part of that includes the sharing by the treatment provider with the parole authorities information about the treatment. In those cases, there may be instances where revocation doesn't act the same way that it does for a person in a civil context. Consent to disclosure is for a specific use or purpose. So this is very important because it may be for treatment or it may be, for example, there are ways that information can be shared as part of a criminal investigation. And those are very narrow, but even in those cases, there's to be a very specific informational need. And then if the information is shared, it really can't be used outside of that specific need, which provided the basis for example, the process which resulted in a court order requiring the disclosure of the information. So the specific use is very important. A lot of times in just the normal health delivery context, if the purpose is for treatment by other providers, there's really nothing controversial, ambiguous about that. But there are a lot of outlying scenarios which we want to be aware of. So sharing for a specific purpose should be included in your consent. And once again, the last thing we want to do is have a challenge to our documents. For example, we spend a lot of time to develop a consent form. And the consent form, we use it for all of our patients, and we use it for a lot of different purposes, for the care in our clinic and the care in our residential program and so on and so forth. Well, we don't want to have a technical flaw in the form itself put in jeopardy our efforts to achieve consent from patients. Prohibition pertaining to redisclosure. This is something that we need to keep in mind, that just because the initial sharing of information was appropriate, could have been by consent, it could have been because there was an exception in HIPAA or Part 2 that pertained to the information, so the initial sharing was appropriate, but the redisclosure of that information is not permitted by HIPAA or by Part 2. So we want to make sure that if we're on either end of that transaction, that we are, cognizant of the fact that although other people may need the information, we may need to kind of have another iteration of our consent process, or we may have to identify an additional exemption that applies to that redisclosure, or there may need to be, a court proceeding to achieve the redisclosure. And surrogate decision-making. Surrogate decision-making, this operates in the most formal sense. So like I said before, someone who's 18 or 19 or 20 has reached the age of majority, they are an adult. Their parents may not believe that, but their parents are not their surrogate decision maker anymore, and so they do not stand in the shoes of the patient in terms of giving consent unless they are the surrogate decision maker. And how do we know if someone's a decision maker? Well, if there's been a court proceeding that appoints them as a guardian, that's an example of how someone formally becomes a surrogate decision maker. And so we want to be careful that we recognize, we honor the rights of surrogate decision makers. Sometimes a court can appoint someone to be a surrogate decision maker. That happens a lot in New York in the mental health and developmental disability context, where there's a lot of mechanisms to appoint a surrogate decision maker. Now, the surrogate decision maker can, agree and consent to the sharing of information. But for example, if you were going to share information with such a person and they were going to sign a consent on behalf of a patient, I think what we would want to do is we want to, it's just as simple, see copies of the surrogate court's order appointing them a surrogate decision maker and so on. So I guess to wrap it up here, what we want to do is we want to look at this as an opportunity to share information. It's very important not to be obsessed or focus too much on the obstacles. HIPAA is an obstacle. That's true. And Part 2 acts as an obstacle. But we want to focus on the path through. What are the things that are going to help us, have a valid and legal sharing of information? And rather than focus on the things that prevent that, we want to look for the exceptions in the law. Does this fall within a public health exception? Is this for treatment and referral purposes? And so on. And then if need be, we're going to go to court. And if we go to court, we want to know exactly what the standards are. Is the person that's going to be receiving it, are they going to be using it for, if they're law enforcement, they're going to be, like I mentioned before, are they going to be investigating a crime? Or are they really just verifying performance of obligations under probation or a community supervision order? So That's the framework for problem solving that I hope is helpful to you. And now I think I'm going to hand it off to Andrew Brown, who's going to pick it up from here.
Thanks, Keith. And good afternoon, everybody. My name is Andy Brown. I am the Recovery Court Coordinator over in Ottawa County, Michigan. And in my role, have been heavily involved in program evaluation over the past several years, particularly as it relates to specialty courts. But there are some lessons learned that we're going to be talking about here in my presentation that apply to any type of probation program or criminal justice intervention, whether that's adults or juveniles. And what I'll be talking about, I think, is going to be more of an evaluation, planning, and data collection experience. It's probably going to be more common to a lot of the jurisdictions and a lot of the callers that are participating in our call today. And that is, we're trying to get data, we're trying to do evaluation planning, or we're thinking about doing it, and we're doing it in a very fragmented system. And we kind of heard that in Keith's presentation that, one, there's a lot of barriers to work through in getting data. And where that data comes from, and legal hoops that need to be prepared and accounted for. And sometimes it just means we have to approach a lot of different agencies separately to get data. And I think that's a common experience for a lot of jurisdictions. But what we're going to hear in the next presentation from Dana is what a really robust collaboration looks like. And I think the Camden Coalition really sets kind of a national standard of what community-level integrated data sharing sets. So we're going to hear two really complementary presentations here. So to get going, I want to just kind of emphasize and help people understand, why we need good data. Kind of an obvious answer there. How we can go about planning for data collection and budgeting and planning for evaluation. So why do we need good data? Right? Well, obviously bad data is going to yield unreliable results. As the saying goes, GIGO, right? Garbage in, garbage out. At the end of the day, we want to know why if our programs work, and we want to understand how they work. And for those who are working in a drug court or a veterans court, mental health court, any of the specialty courts, chances are your program is grant funded, and somewhere down the road, you would like for your local funding unit to pick up the personnel costs or the program costs. That's absolutely the position that we're in here in Ottawa County. And our ability to make funding requests hinge directly on good evaluation and the outcomes of the evaluation of our drug court. And the second thing is bad data. If you don't have complete data, if you have lots of missing data, you don't have the key variables that are needed to run the tests, it's just going to result in limited testing that can be done. So good data, it gives more opportunity for more rigorous statistical testing. You can maximize evaluation design and work with your evaluator to get more robust testing that's going to be done. And that's the difference between what we call descriptive statistics, which a lot of us are familiar with. That's going to be your pie charts and your bar graphs saying, hey, we had 50 people in our drug court who were opiate users and 30 people who were crack cocaine users. But what we want to know, and with good data, what you can start to do in maximizing your evaluation design to start asking more inferential questions. And what that looks like is, hey, we have a 24-year-old Caucasian male with 3 prior felony charges who's a crack cocaine addict and received 30 hours of treatment in our program. What were the odds of him completing the program? And start extrapolating outcomes. And the more data you have, the more you can get into those inferential statistics. And again, the more data, the more robust you have, the more value you're going to get for your money when purchasing evaluation services. Because the evaluators that you're going to be contracting with or working with, again, they can only test the data that you give them. And if it's poor quality data or it's limited data, you're just not going to get as much. So a few truths about data. Data is difficult to obtain. Sometimes there's no way around that. First, we have a lot of the legal challenges. And we heard Keith talk about that and how to navigate some of those. But what agencies are we getting data from? I can, speak from my experience here. We have 2 treatment providers. So that's 2 different relationships that need to be maintained. That's 2 different requests just to get clinical data. We have 6 law enforcement agencies in our county, none of whom communicate together or share the same database. So if we need to get arrest data, that's 6 different law enforcement agencies you have to go to. The jail data, if we need booking and length of stay in the jail, we're the court, we're the 3rd branch of government, the sheriff's department is the 2nd branch, executive branch. So you have to make a separate request to the jail. And if we want to get data for our felony population through the Department of Corrections, we need to make an approach to the Department of Corrections. So lots of different requests, lots of different challenges. We want to be able to get primary source data from these agencies, but it's all individual separate requests. Each of those agencies has their confidentiality concerns and requirements in releasing data, and that needs to be planned for. But let's say we start to get all of that data, right? The next question is the data that we're getting, how good is the data? And at the end of the day, data is only as good as the person who inputted it or entered it into the system. So also, as you're making the data requests and thinking about planning this data, again, what are the data sources? But then also be asking, what are the limitations of the data? An example of this would be in the state of Michigan, we have 2 criminal record repositories, one that's maintained by the State Court of Administrative Office and one that's maintained by the Michigan State Police. Not all courts and not all law enforcement jurisdictions upload their data into either of these systems. And interestingly enough, the 2nd largest court jurisdiction in the state of Michigan doesn't upload their disposition data into the State Court Administrative's repository. So there's about 500,000 people in this 2nd largest jurisdiction, and for those that are involved in that local court system, none of that criminal history data is available in the state. So again, being aware of the limitations, what agencies are uploading data, things like that are really important. So as you start to plan and thinking about doing your evaluation, your data collection, really spend some time, and if you already have an evaluator, perhaps on staff or in your local municipality that does program evaluation, or if you have to contract with someone, take the time to do a good planning process up front. So what are you evaluating? Are we looking at a qualitative process evaluation? Are we trying to do an outcome measures, like a recidivism study? Are we trying to evaluate cost or the impact? What program elements influence successful completion or the outcomes from our program? Drill down and answer the question, what are we evaluating? What do we want to know? What are the questions that we're trying to answer? And then it's, where is the data going to come from? List out the data points and the data elements that you need. Create an inventory of that and identify the agency or agencies that you're going to need to approach and partner with to get that data. And who's going to collect the data? What staff are going to be assigned to this? And how long is the data collection process going to take? And it can take a long time. Sometimes you might get a data dump, is kind of the jargon that's used, and that is, hey, the Department of Corrections can send you one big Excel file with all the information you need. Sometimes getting the data, like in our experience with our treatment episode data for our participants, we have to go through the billing records by hand to get that data, because there's no aggregate report that can be generated. So if you're having to get your data and collect that data and get it entered by hand versus an Excel or CSV file that comes down, big differences in the time commitment for you as you go through that. And the next thing with data is, as we've been talking about, data coming from all of these different sources. So it's great if you can get the criminal history data from the Michigan State Police, and you can get criminal history data from the State Court Administrative Office, and you can get the clinical records from your 2 or 3 treatment providers, and you can get the jail records from your jail. So now you have these data sets from all of these agencies. How do you combine them? How do you bring them? So John Smith, who has case information in all of those data sets, you can put all of that together. And it's critical that there's a set of common identifiers between each data set. And if you don't have that, it's not possible to merge that data. You're sitting on siloed information from all of these different agencies. So spend time in that planning process as well. What are the common identifiers that you can use to link the data sets from all of your different sources? And for criminal justice practitioners, that might look like a driver's license number. In Michigan, we have what's called the state ID number. It could be date of birth, maybe the last 4 or 6 digits of a social security number. Really put thought into what identifiers are common between all of the agencies. Because if you're working really hard to get all this data, you want to be able to use it all as well. And the other thing to keep in mind as well, the most rigorous research design that can be carried out is what's called the randomized control trial. And particularly in criminal justice research, it's really tough to pull off a randomized control trial. So often, and basically the idea of a randomized control trial, let's say somebody's coming into a drug court program and you have 2 applicants and they meet all of the eligibility for coming into drug court. You're going to flip a quarter, and if it's heads, one person is going to go into drug court, and if it's tails, one person's going to go onto regular probation, and then you're going to measure the outcomes 1, 2, or 3 years down the road. You just don't know how people are going to perform. But we often just can't do those types of research designs, so we use what's called a quasi-experimental research design. And that is we create a matched group, our drug court people, to a group of regular probationers with similar characteristics. They've already completed probation, but we want to try and determine, did drug court outperform regular probation? And there's statistical methods for doing that. But to really be able to do a good quasi-experimental research design where we can compare the outcomes of drug court to regular probation, it takes a lot of data. And you need the same data for your drug court people as you do for your matched comparison group, or regular probationers. So you want to be able to ask in that research design, is the data available or the same data available for both groups? Because you need to measure the same thing. You wouldn't want to measure all arrests for the drug court people and then all guilty pleas or convictions only for the matched comparison group. You need to measure arrests to arrests for both groups to have valid outcome results that you can use. So again, as part of that data collection process, what data are you able to get for your participants, and can you get that equivalent data for your matched comparison group? And again, that data and some of the key data you're going to want to look at would be budget and cost data, overhead, personnel cost, court case flow data, all of your program level data, units of treatment, how many drug tests, who had positive drug tests, how many case manager contacts, surveillance contacts. That becomes important information. And then, of course, criminal history when we're trying to measure recidivism. And knowing, can we get the arrest data? Can we get conviction data? Where are we going to get that data? Ideally, you want to be able to get data from across your state, or if you can get across the country, even better. But again, can you get that equivalent data, not only for your program participants, but for that matched comparison group? Okay. And as we start to wrap up here, and we'll talk more about this in the Q&A section of things for those that stick around. Evaluation, it's a time-consuming process, and it's an expensive process, and it's an investment. One of the best ways for criminal justice programs to fund them, the Department of Justice through the BJA grants, definitely support evaluation. SAMHSA supports evaluation with their drug court enhancement grants as well. So grants are a great opportunity to fund evaluation that way. But know that they can be very expensive. It's not uncommon to see a six-figure price tag, or a price tag that's over $100,000 for an evaluation, depending on the research design and the level of effort that goes into it. And evaluations, it's time intensive. Think of all that data collection and the planning process. So you want to be able to account for that time to do the data and for the evaluators to clean it up and do the analysis. And it's reasonable to expect that it's a 12 to 24-month process. And it can be done faster as well, but definitely expect, a 12 to 24-month process. And that wraps up my presentation. We're going to hear from Dana Fundell now.
Hello, it's nice to join you all. So I'm going to be talking today about how you use cross-sector data exchange to improve coordination of services for patients that are experiencing complex needs. And what we're really going to focus on is specifically how we use relationships with community partners to deepen our ability to implement cross-sector data sharing, and really looking at how is this grounded in optimizing care at the patient level. So how do you build out use cases and engage staff to really activate the data in a way that improves care for patients and clarifies the next steps as a community for where you can move forward within your data sharing process. Throughout the presentation, I'm not going to specifically highlight each intercept that we talk about, but we really feel like the work that we're doing in Camden touches on intercepts 2, 3, and 4 from the SAMHSA intercept model. So at the Camden Coalition, we are an organization that is focused on how do we transform the healthcare system that we work within in order to provide more holistic care for patients with complex health and social needs. And this overall mission has really, from the beginning, had us really take kind of a wide view about the types of partnerships that we needed and the types of providers that we think of when we look at how to best serve these patients. So just to give you a little bit of context about the area that we're doing our work, Camden is a small city. There's about 71,000 people. And while New Jersey is one of the wealthiest states in the country with a median household income of $72,000, Camden's median household income is closer to $26,000, and about 60% of the individuals in our community are on some type of public insurance, with Medicaid being the most common. Another kind of context around our work is that Camden City tends to have the worst health outcomes in the state and ranks in the bottom 5 across most health indicators across the 21 counties. So in our initial work, we really, from the beginning as an organization have focused on clinical observation and data analysis. So what you're seeing on this slide is a representation of some of our initial work where we really started looking at patients that had the most frequent utilization of our healthcare systems, and really revealing that 1% of patients were accounting for about 30% of the hospital costs in Camden. And this became really relevant for kind of informing a lot of our work around this aspect of hotspotting. So how do we use data to target evidence-based services to patients that have complex needs? And from the beginning, I guess our work has focused on both this access to data and then how do you bring together providers to look at that data in order to inform the next steps that they take. And over the years, we've run a variety of different interventions, but really throughout all of our interventions, there's a focus on connecting patients across sectors. So because we're looking at this intersection of complex health and social needs, we've worked across social service, criminal justice, legal system, behavioral health, and medical settings, because those are the needs that are emerging within our patients. Our current work and care teams really reflects that focus, and we have multidisciplinary teams and program offerings such as a Housing First program and a medical legal partnership. So in addition to our work that we do with patients, we closely work with a variety of community partners to implement new programs, workflows, and kind of activation of that cross-sector data. And both our patient and our systems work is facilitated by our Health Information Exchange, which is the Regional Health Information Exchange, as well as our data analytics team, which uses data from a variety of sources to both inform our work and the work of our partners, but also to help evaluate our efforts through some of the types of complex evaluations that Andy was just referring to. Finally, we are a coalition, so a big part of our work is convening partners. And then we work to synthesize these learnings from our patient and systems work into our policy and advocacy approaches. So for this presentation, we want to focus on several specific relationships that we've worked to build out over a number of years. And those are the relationships that we have with the Camden County Jail, as well as their clinical services provider. So our relationship with the county jail has allowed us to build out a number of collaborative programs and to receive data sets that help with our population level analysis. So Andrew just went over a lot of work and considerations at the population level. So as he said, we're going to focus our work on the patient level, but my colleague Aaron, who is our Director of Analytics, will be joining us in the discussion panel, and he'll be available to answer questions about some of that population level work, which is the Camden Arise data set. And this data set combines information with our cross-sector data from cross-sector data systems to create a multidimensional picture of citywide challenges, which help drive better decisions and allocation of resources, as well as some citywide conversations about the root causes of some of the different public problems that we see in our community. In addition to the work that they've done at the population level, our relationship with the county jail has allowed us to actually pilot patient-specific programs, which I'm going to talk about a little bit, and then build on those programs to help them expand the offerings that they have within the Camden County Jail. Our relationship with their clinical provider has really focused on another data sharing mechanism which we use, which is our Health Information Exchange. And so they were actually one of the first users of our Health Information Exchange when we launched it in 2010. And our relationship with them has really expanded over the years, which has grown to a bidirectional data sharing agreement where they're actually pushing summaries of their care into our Health Information Exchange. And they began expanding their offerings of medications for addiction treatment as a part of their primary care services. So they don't have a separate MAT program. They've actually integrated it in to their primary healthcare approach, which, as Keith alluded to, with some of the considerations around 42 CFR concerns and different data sharing sites, depending on how different contributing providers integrate their services, it does open up some opportunities to really look at whether or not data is considered 42 CFR. And that really is a provider-to-provider consideration, which he spoke to. But we just want to acknowledge that this is a part of the primary care offering within the jail, which gives us a little bit more flexibility. And then in 2020, we began a collaborative process with them to really augment their MAT services. And so I want to really highlight that these relationships are symbiotic. So as we move forward with one, it really helps reinforce the other relationship. For example, as the county shared more data with us and saw more value in this data collaboration and exchange, they decided to actually add it into their contractual requirements with their clinical provider, so the clinical provider have the ability to contribute data into our Health Information Exchange. So we really see these two areas as definitely like a symbiotic approach. So the final thing that I want to say before I go into our HIE and some of the other things is that our approach is really based on what Keith said earlier around taking a bite at a time. So we're really focused on how do we share minimum levels of data and then build from there and really make sure that we're taking advantage from a workflow perspective of the data that we have available. And then as we establish trust and build out really defined use cases, we can look at what additional data sharing is needed and will be beneficial to all parties. So our health information exchange is a patient-level data exchange that is not exhaustive. So there are a number of different behavioral health and substance use provider facilities that don't contribute data, but are able to access the data from the medical side and from other organizations that are not 42 CFR designated locations. And this data and this work with the Health Information Exchange has allowed us to better activate the use of data that's coming in from the emergency department, inpatient and outpatient settings in order to improve the intake process for the jail's behavioral health and substance use disorder programs, as well as help coordinate care post-release to support kind of better continuity of care across the system. So in our previous work, when we were doing a patient-facing program within the Camden County Jail, we ran a partnership program in partnership with other providers in the reentry space. So we used the Health Information Exchange to help identify patients that we should triage for programs and to verify their eligibility. And then with patient permission to provide ongoing monitoring through use of admission, discharge, and transfer notifications within the HIE to help our care team be able to stay in contact with patients as they moved across different systems. But what's important to highlight is that while the HIE really provided a foundation for that, we really supplemented our care coordination work by establishing relationships with the staff directly in the jail. And this involved having individual care coordination conversations between nurses and social workers, as well as engaging in regular contact with some of the different community partners that were crucial post-release, such as mental health and substance use treatment providers. As you can see on the slide, a high percentage of the panel had mental health and substance use diagnoses. And so with patient consent, our teams were able to share out the mental health and medical information from the jail directly to the providers that were taking over their care upon release. And with those groups, we also found it really crucial to have a consistent touch points to really keep those relationships active. So our pilot ended in 2019, but building on the lessons learned from the population data analysis that the Camden County Jail had participated in, as well as the programs that we were doing with them, the jail has really worked to expand its existing programming to support increased access to mental health and substance use treatment within the jail. And their work and the work of their community partner has really been amazing. I mean, I think that all of the work that we do is really in collaboration and because of the amazing partners that we have in Camden. And so the Camden County Jail is now providing MAT to as a standard part of their intake and as a standard part of their primary care offering. In 2019, 900 patients were released from the jail as a part of an active MAT program. And they've really built out, also extensive resources around providing additional support for patients with co-occurring diagnoses. So as our program ended, and as the jail and their medical provider have really built out their services, our role has transitioned from providing direct services to supporting the programs that the jail and the medical provider are doing. So we now are involved in helping support their improved data coordination, both within the jail, between internal data systems, as well as their ability to do coordination with external partners. And so what this looks like is that the jail administrators and clinicians use the HIE as a part of their standard intake process to understand the patient history, as well as identify and verify patients with diagnoses that would qualify them for additional support groups, and to help the jail providers understand where to go next for more detailed information about patients. The external providers are then able to access summaries of care that include medications but no treatment notes to help coordinate care for ongoing treatment post-release, as well as know that their patients are receiving services when incarcerated. So we have regular touch points with the external providers to gather information from them about how the jail data is being used and opportunities for workflow and data improvement. So how does this work? The patient consent process is currently built into the consent process at all of our providers. So our approach is based on every individual accessing the HIE having a treating relationship with the patient. So as a part of their intake process to any of their settings, the HIE consent is a part of that general intake with all of our providers, which gives the option for patients to either request that their data is not accessed, or to let their provider know that they no longer want their data to be available in the HIE, which then each clinical provider can connect the patient to to have that data removed. And then patients in the jail setting do consent to their behavioral health and substance use data being shared, but we're really focused on activating data that is operating under HIPAA protections rather than 42 CFR, and optimizing those workflows. And then we've been able to build out specific use cases where additional data may need to be shared, but we're working on piloting those workflows between a limited number of providers versus total visibility within any treating provider within the HIE. So we've basically been able to set a strong foundation, which then we're building on for specific use cases. So how do we identify these different gaps in areas where we need additional data sharing? With the advice of our partners and with different interdisciplinary teams, we really work on engaging in workflow mapping to understand the specific data points that are needed, both in order to strengthen the ability to track data within a contained program within the jail, but also between the jail and external partners. And the same things that, the same methods that we use with our patient work, of regular meetings, clarifying needs, and having frontline staff and partner agencies talk directly, really apply to these system things. So we really want to get frontline staff in the room. We really want to connect agencies directly to each other to talk through their data sharing needs. And what this works for is to help us identify what are the minimum data sharing points that are useful. So we found that minimum amounts of information, such as just knowing where a patient has received services or is receiving services, has a huge impact in clinicians being able to coordinate with each other. It also has helped us identify kind of how we would layer on additional information, such as diagnoses, medication, and dose to coordinate care, which is being done between some of our different participants. But it's also really clarified for us that we don't need to share treatment notes. We really have aligned as a community of saying that those are things that are, even with 42 CFR protections in place, are not necessary to be transferred through the health information exchange. So it's really helped us clarify not only what can we share, but also what do we think we should share, and what do we really have use cases for around who specifically views which pieces of data. And I think what's nice for this is that it's allowed us to have clear use cases for providers to also be able to explain to patients who ask what their data would be used for. So it's leading us to a place where we can really continue to have a more and more patient-centered consent process where they really understand exactly how their data would be used with specific care coordination examples. Finally, it's helping us assess what evaluation metrics are needed to improve care so that we can be looking at what actually relates to our ability to improve the services we provide, and have kind of a metrics that we're looking at that are really informed from the lessons on the ground. So we have a few lessons learned, which I just highlighted. which is, looking for, acknowledging the complications of 42 CFR and the need for ongoing conversations and clarifying which parts of the data are protected and which parts aren't, and then which parts of the data may not be protected, but that we still, from a patient autonomy and understanding the role of stigma, may want to protect. And it's created space for us as a community to look at external layers that we may want to add on, such as online vendors that help manage consent interface, so that we can begin parsing medical, behavioral health, substance use data, so that patients don't have to redact their whole HIE participation. They could choose to restrict one area of care or another. And then it's also, helping us look at how, overall how we build these relationships, and really grounding them in patient care allows us to play a more neutral role to keep a lot of different providers at the table. So key takeaways are, this aspect of relationships take time. We have benefited from being in the community for a long time and having a lot of longstanding partnerships. But what we really want to highlight is start where you can and then build how you can. And ongoing feedback about the value that each person is providing really helps keep people at the table. So thank you all so much for your time, and we're excited to answer questions in the discussion portion.
Terrific, thank you all. This is Richard Van Dorn again. I realize that we've run over our 1 hour allotment for the webinar presentation. We are still going to go into the Q&A in a couple of moments, but we're still going to end that at 4 o'clock. So I'll be brief in my wrap up here. The Q&A, if you want to submit any final questions, please do so. There will be a certificate of attendance that is downloadable. And a quick reminder, this is not a CEU. It's for portfolio use only, so feel free to download that. Also, there's a webinar supporting document that might be useful that I'd like to point out. It is entitled Data Collection Across the Sequential Intercept Model. You heard Dana mention intercepts 2, 3, and 4. This Essential Measures webinar supporting document identifies measures across the intercepts that you can consider in building your data sharing program or primary and secondary data collection strategies. To learn more about subsequent events in this series, including July's webinar, which will focus on mechanisms and platforms for information and data sharing, as well as other offerings from the GAIN Center, we encourage you to subscribe to the GAIN's listserv. Also note the contact information for SAMHSA and SAMHSA's GAIN Center, including the phone number for the GAIN Center, where you can call for phone-based technical assistance. And finally, in closing for this event, thank you for your time and participation. We encourage you to join Keith, Andrew, Dana, and Aaron for the discussion group that is taking place next. We will head over now to the Adobe Connect platform and join in that discussion. See you all over there shortly. Thank you.